This is the Baker Act Training Minors Module 3. The focus of this module will be psychotropic medication in relationship to the Baker Act in terms of administration of the psychotropic medication, its discontinuance, responsibilities of the parent or legal guardian, and the agency, and I'll identify the role of the guardian ad litem in regards to minors.
When we got the right meds, and again, the proper therapy, a total change.
Changed overnight almost.
And now you're doing
The
just
severity
fine, Andrew.
greatly diminished.
Doing beautifully. Yeah. How did you feel about it all, sweetie? Yeah.
Parents always have the right to consent to treatment while a youth is in custody, with two exceptions. Parents always retain the right to consent to examination or treatment of their child. The only exceptions are if there is an injury or illness requiring immediate treatment, or if there is an ex parte order authorizing treatment. After emergency medical treatment is provided without parental or guardian consent by DJJ or DCF, then that agency needs to notify the parent or guardian as soon as possible and document in the medical records the reason consent for the parent or guardian was not obtained. After a detention petition or a petition for delinquency has been filed, the court may order the child that's named in the petition to be examined by a physician. The court may also order the child to be evaluated by a psychiatrist or a psychologist. If it is necessary to place a child in a residential facility for such evaluation, the criteria and procedures that are established in Florida Statute 393, 394, or 397, whichever is applicable, must be used.
I had my first major episode of OCD at about 14 years of age. It was very frightening, especially because no one around understood what it is or even tried to talk to me about what I was going through. They thought I was crazy. My major depressive episodes usually begin with weeks or months of OCD, or end with OCD. That I learned years down the road. OCD and depression are terrible illnesses. They rob you of ability to feel pleasure.
A physician should be notified immediately by the person taking the child into custody or the person having custody if there are any indications of physical injury or illness, or the child should be taken to the nearest available hospital for emergency care. A child may be provided mental health, substance abuse, or developmental disability services in emergency situations. After a hearing, the court may order the custodial parent or parents, guardian, or other custodian, if found able to do so, to reimburse the county or state for the expenses involved in such emergency treatment or care. Legal custody is a status created by the court order or letter of guardianship. It defines whether an agency or an individual has the right to physical custody of the child. This includes the responsibilities to protect, train, and discipline the child. The agency or individual must also provide food, shelter, education, and ordinary medical, dental, psychiatric, and psychological care. DCF can have a medical screening performed on a child removed from the home or maintained in an out-of-home placement without authorization from the court and without consent from a parent or guardian. In no case does this subsection authorize the department to consent to medical treatment for such a child. Except as otherwise provided before the department provides psychotropic medication to a child in its custody, the prescribing physician shall attempt to obtain express and informed consent from the child's parent or legal guardian. The department must take steps necessary to facilitate the inclusion of the parent in the child's consultation with the physician. However, if the parental rights have been terminated, the parent's location or identity is unknown or cannot reasonably be ascertained, or that the parent declines to give express and informed consent, then the department may, after consultation with the prescribing physician, seek court authorization to provide the psychotropic medications to the child. Unless parental rights have been terminated, and if it is possible to do so, the department shall continue to involve the parents in the decision-making process regarding the provision of psychotropic medications. If at any time a parent whose parental rights have not been terminated provides express and informed consent to the provision of psychotropic medication, then the requirements of this section that the department seek court authority do not apply to that medication until such time as the parent no longer consents. The prescribing physician must discuss the proposed course of treatment with the child in a developmentally appropriate language that the child can understand. That physician must explain the risks and benefits of the prescribed medication to the child, and then include some of the same things as they would with the other consent for treatment, including alternative treatment options, the method of administering the medication, an explanation of the nature and purpose of the treatment, the recognized side effects, risks, and contraindications of the medication, possible side effects of stopping the medication, how the treatment will be monitored, and the physician's plan to reduce or eliminate the ongoing administration of that medication. The prescribing physician must ascertain the child's position with regard to the medication and consider whether to revise the recommendation based on the child's input. The child's position is to be noted in the medical report. It is the physician's responsibility to inform the child as clearly as possible and as fully as appropriate. However, the child's failure to understand or to assent to treatment is not by itself sufficient to prevent the administration of a prescribed medication. Likewise, the child's assent to the treatment is not a substitute for express and informed consent by a parent or legal guardian or a court order. Children are more likely to be successful in treatment if they fully understand and participate in the treatment decision. If a child of sufficient age, understanding, and maturity declines to assent or agree to the psychotropic medication, the dependency case manager or child protective investigator will request the children's legal services request an attorney be appointed for the child. Whenever the child requests the discontinuation of the psychotropic medication and the prescribing physician refuses to order that discontinuation, the dependency case manager or child protective investigator will request that the children's legal services request an attorney be appointed to the child. Children's Legal Services will notice all parties and file a motion with the court presenting the child's concern, the physician's recommendations, and any other relevant information. Express and informed consent means voluntary written consent from a competent person who has received full, accurate, and sufficient information and explanation about a child's medical condition, medication, and treatment to enable the person to make a knowledgeable decision without being subjected to any deceit or coercion. Express and informed consent for the administration of psychotropic medication may only be given by a parent whose rights have not been terminated or a legal guardian of the child. Sufficient explanation includes, but is not limited to, the following: providing and explained in plain language by the prescribing physician to the consent giver. They'll tell the medication, the reason for prescribing it, and its purpose or intended results, side effects, risks, and contraindications, including effects of stopping the medication, method of administering the medication, and dosage range when applicable, potential drug interactions, alternative treatment, and the behavior health or other services used to complement the use of the medication when applicable.
John is a 17-year-old in the custody of DCF. He requires medical treatment related to his substance abuse. What if his parent or guardian is available but refuses to consent to his treatment? If a parent or legal custodian refuses to consent to the necessary treatment, a court order is required unless the situation is an emergency as defined by Florida Statute 743.064. DCF can consent to necessary medical treatment if related to suspected abuse, abandonment, or neglect by a parent, caregiver, or legal custodian. This authority is limited to the time reasonability necessary to obtain court authorization.
In the absence of consent from the parent or guardian, DCF must acquire court authorization to provide the prescribed psychotropic medication to a child in its legal custody. A written departmental report must justify this legal motion. This report must document the physician's effort to obtain express and informed consent to provide the medication and other treatments. In addition, the physician's signed medical report must provide an explanation of the purpose of the treatment, possible side effects, risk and contraindications, drug interaction precautions, effects of stoppage of the medication, how the treatment will be monitored, a statement indicating that the above explanation was provided to the child's caregiver and to the child if age appropriate. Documentation indicating whether the psychotropic medication replaces or supplements other prescribed medication or treatment needs to be included. In addition, how long the child is expected to take the medication, and then any additional mental health, medical, or other services the prescribing physician recommends. Psychotropic medications may be administered in advance of a court order in hospitals, crisis stabilization units, and state-sponsored inpatient psychiatric programs. DCF must seek court authorization within 3 working days after beginning the medication. This flowchart represents a decision tree in terms of obtaining medical treatment for a child. If the child requires the necessary medical attention, then the first thing to ask is if a parent or legal guardian is available for consent. Depending on the response to that question, then either they would be contacted and DCF or their quote agent had time-limited authority to grant consent for medical treatment, or DCF or their agent would request a court order to authorize medical treatment for the child. If the parent is available, then trying to get consent from them or the legal guardian, it would be the priority for the medical treatment, and the end result would be that the child would receive the necessary medical treatment. Psychotropic medications means, for the purpose of this course, any chemical substance that's prescribed with the intent to treat psychiatric disorders, and those substances which Those prescribed with the intent to treat other medical conditions have the effect of altering brain chemistry or involve any of the medications in the categories listed below. The medications include, without limitation, the following: antipsychotics, antidepressants, sedative hypnotics, lithium, stimulants, non-stimulant attention deficit hyperactivity disorder medications, anti-dementia medications and cognition enhancers, anticonvulsants and alpha-2 agonists, and any other medications used to stabilize or improve mood, mental status, behavior, or mental illness.
A normal person's brain, they have enough serotonin, but in my brain, I don't have enough serotonin. The medication are selective serotonin reuptake inhibitors, SSRIs. They provide the extra serotonin. The last year has been super. My OCD didn't take up more than 10 minutes of my day.
And they just found the right combination of drugs?
It was a perfect combination of drugs. I found the perfect combination that worked for me. It was a really high dose, but it worked. I would laugh. I would spend hours just laughing at things.
Again, unless those parental rights have been terminated, DCF must involve the parents in decisions regarding the provision of psychotropic medication. If DCF continues to provide psychotropic medication when parental authorization cannot be obtained, the parent or legal guardian shall be notified as soon as possible. The child's departmental record must include the reason parental authorization was not obtained and an explanation of why the medication is necessary. In addition, anytime DCF seeks a medical evaluation to determine the need to initiate or to continue a psychotropic medication, then DCF must provide pertinent medical information to the evaluating physician. If a child is prescribed psychotropic medication and then removed from their home, DCF may take possession of and continue to provide medication as prescribed until the shelter hearing. It must be a current prescription in its original container. If the department is advised by a physician that's licensed under Chapters 458 or 459 of the Florida statute that the child should continue the psychotropic medication and parental authorization has not been obtained, then the department shall request court authorization at the shelter hearing to continue to provide that psychotropic medication and shall provide to the court any information that's in its possession to support that request. Any authorization granted at the shelter hearing will continue only until the arraignment hearing on the petition for adjudication or 28 days following the date of removal, whichever comes sooner. Children who are in the legal custody of the department may be placed by DCF without prior approval of the court in a residential treatment center that's licensed under 394 or a hospital licensed under 395 of the Florida statute, hospital for residential mental health treatment, or they may be placed by the court in accordance with an order of involuntary examination or involuntary placement pursuant to the Baker Act or the hospital provisions. All children placed in a residential treatment program under this subsection must have a guardian ad litem appointed.
I just want to thank you for being a guardian ad litem.
For people who may have never heard of what a guardian ad litem is, describe that to us in the role that they take in the justice system.
Guardian ad litem is a person who takes the place of a child's voice in court. They are the most important voice that I hear when I hear these cases.
Guardian ad litem volunteers do not need to have a legal background.
They take an oath in the courtroom and are appointed to a case by a judicial order and released from a case by a judicial order.
The Guardian ad litem program really are the boots on the ground for us. We've had some guardian ad litems who have such a tight bond and relationship with their child, their juvenile, that the guardian ad litem is the only person that this child can talk to.
A petition for involuntary placement shall be filed in the circuit court when outpatient or inpatient treatment is deemed necessary. When inpatient treatment is deemed necessary, the least restrictive treatment consistent with optimum improvement of the patient's condition shall be made available. Each detention center and residential treatment program shall have available either within the facility or by written agreement or contract with off-site providers provisions of psychiatric services for treatment of serious mental disorders. Psychiatric services shall be provided by a psychiatrist or by a licensed and certified psychiatric advanced registered nurse practitioner, ARNP, who works under the clinical supervision of a psychiatrist. The psychiatrist or the ARNP shall only prescribe psychotropic medications which address the use's specific diagnosis and target symptoms. If a psychotropic medication is required, then the lowest dose of medication necessary to achieve that therapeutic effect may be used, bearing in mind the potential benefits and risks. The use of more than one psychotropic medication as part of a mental health treatment regime requires documented clinical justification for each psychotropic medication that's used by that psychiatrist or the ARNP. Psychotropic medications shall be only one component of that therapeutic program. Additional treatment modalities such as individual, group, and family therapy, behavioral therapy, substance abuse counseling, and psychosocial skills training shall be utilized in conjunction with the use of the psychotropic medication. The court may not order the discontinuation of prescribed psychotropic medication if such order is contrary to the decision of the prescribing physician, unless the court first obtains an opinion from a licensed psychiatrist, or, if they're not available, from a physician that's licensed under Chapter 458 or 459, stating that more likely than not, discontinuing the medication would not cause significant harm to that child. If, however, the prescribing psychiatrist specializes in mental health care for children and adolescents, then the court may not order the discontinuation of that prescribed psychotropic medication unless the required opinion is also from a psychiatrist who specializes in mental health care for children and adolescents. The court may also order the discontinuation of prescribed psychotropic medication if a child's treating physician states that continuing the prescribed psychotropic medication would cause significant harm to the child due to a diagnosed non-psychiatric medical condition. Psychotropic medication shall not be used as punishment or for staff convenience, discipline, coercion, or retaliation, as a substitute for meaningful psychosocial rehabilitative service, or in quantities that lead to a loss of functional status. There shall be no PRN or standing orders for psychotropic medications, and there shall be no emergency treatment orders for the use of psychotropic medications as a chemical restraint. Chemical restraints means a medication that's used to control behavior or restrict a youth's freedom of movement, and it is not standard treatment for that youth's psychiatric condition. Those behavioral health services are to be provided to children that are residing out of home without delay once the need for such service is identified. Prior to prescribing a psychotropic medication, the physician must consider other treatment interventions that may include, but not are limited to, medical, mental health, behavioral, counseling, or other services. All decision making must be guided by the Child and Adolescent Comprehensive Mental Health Act that we reviewed in Module 2. Those principles are important to comprehensively addressing all the concerns in a child's life, such as family, legal, health, education, and social and emotional issues, as well as to provide behavioral support and parent training so that the child's behavior and mental health issues can be addressed in the least restrictive setting and in a comprehensive treatment plan. Whenever a new psychotropic medication is either prescribed, discontinued, or the dosage is significantly changed, then a parent or guardian are to be notified and consent obtained unless the youth is 18 or older and is emancipated and is responsible for authorizing their own health care, or if a physician determines that immediate treatment is needed. If a court order is required to obtain authorization to administer psychotropic medication, then the prescribing physician must complete and sign the medical report form. Psychotropic medication that's prescribed or significantly changed is to be documented on page 3 of the Clinical Psychotropic Progress Note Form, HS006, or if an agency develops their own form for use, then it should contain the same information as listed here. Each youth who is receiving psychotropic medication is to be seen for medication review by the psychiatrist or the ARNP at a minimum every 30 days. Medication review is to include evaluating and monitoring medication effects and the need for continuing or changing the medication regime. Co-located Children's Crisis Stabilization Units, or Integrated CCSU, and juvenile addiction receiving facilities exist in several areas of the state. These behavioral crisis units provide emergency, mental health, and substance abuse services that are integrated within facilities licensed and designated by the Agency for Healthcare Administration for persons under the age of 18 who meet the voluntary or involuntary examination or admission criteria under the Baker Act or the Marchman Act. These include those having coexisting mental health and substance abuse disorders. The services must meet all the licensure requirements for CSUs, and the standards that are implemented specific to substance abuse services must meet or exceed existing standards for addiction receiving facilities. Substance abuse and mental health issues will be discussed in detail in the Marchman Act training series. This concludes the coursework for Module 3 and for the Baker Act Minors Training. Do you know the parental or guardian rights to consent for treatment for a minor and the 2 exceptions? Can you describe the department's action that they would take if medical treatment is needed without parental consent? Can you identify who it is that would order the treatment for a child in such a situation where they needed that mental health service? Can you define legal custody and psychotropic medication? What involvement can a child have in the decision-making process regarding their own treatment? And who can be a guardian ad litem? What are the responsibilities entailed? If you are comfortable answering these questions and you're ready to move on to the knowledge review, go back to that M3 tab, click on the knowledge review, and go ahead and take that exam. If you're feeling like you did not answer those questions or are unsure of the content, then go back to the beginning of this module and review it again, and then take the knowledge review. To complete the knowledge review, go back to the M3 tab and click open the Module 3 Knowledge Review section. After completing the knowledge review, you may decide that you need additional study of this information. If so, return to the beginning of this module. If you correctly answer 8 out of 10 questions on this knowledge review, you may choose to go forward to the course exam. Take the required survey and then move ahead to the pre-certification section to complete the process for printing your certificate for this course.